Okay, we're ready to start the continued public hearing on site plan approval under 121 Rolling Lane.
I ended up receiving a letter from Attorney Jonathan White. Dear members of the board, please be advised that the owner of the above referenced property, 121 Rolling Lane LLC, Kenneth B. Stevens, manager, hereby withdraws his petition for site plan approval for the construction of a house on a lot in excess of 6,000 square feet, residential gross floor area. So the planning board had advertised it, had held the public meeting, had held a sidewalk, and the way the Mass General Law works is that the board has to vote to accept his withdrawal.
I'll defer to Joel on that. I know special permit, variance. I'm not certain site plan approval, which is a by right use that can be shaped, but the by right use, if the applicant decides not to go forward, that requires planning board approval, but I'll defer to town council.
Right, so I had written an email to the chair and to Betsy 10 or so days ago. It wasn't quite a paragraph. I didn't say, regardless of what the form of the application is, the planning board doesn't have to allow an acceptance. Somebody can always, allow a withdrawal. Somebody can always withdraw. There are other implications, but when I wrote my email, I was thinking in the back of my mind that this site plan's a special permit, which it's not. So it's just, as you know, it's just a site plan approval, as we were discussing earlier. So under either model, in any event, whether you're a special permit or just an administrative site plan approval, an applicant has the ability to withdraw. They don't need the board's permission. The only difference about it not being a special permit is the issue I got into my email about whether or not it's with or without prejudice. That only applies for special permits, not for site plan review.
So, but the short answer is you agreed with Jonathan.
Yes, yeah, that had been my opinion, that they had the ability to withdraw.
Without comment, and without the agreement of the planning board, just.
Without the agreement of the planning board, right.
Yeah, so it doesn't require a vote.
Right, now, however, the planning board has something it wants to say. Now, then I think you've commented on, you've opened a public hearing. Public hearing continues until tonight. They said they're withdrawing the application. Has it been filed with the town clerk?
Not yet.
Request to withdraw?
Because
No.
I was under the impression that it needed to be voted.
No, was the letter to withdraw filed with the town
I
clerk?
don't believe so.
No, it was just sent at the beginning of last week.
Yeah, I got it on the 20th.
Yeah, so, no, it's just sent by letter, by email. I can't remember if I sent it. Just
Okay.
Yeah. So what you're saying is that it hasn't actually, it's not an official,
It's not
it hasn't been officially registered as a withdrawal.
Right, the
So
town
there-
clerk is
It
the
has to be
timekeeper on
different
all.
clerk.
Well,
Yeah.
if that is, I'm not certain that makes a difference, but if it does, you see what we intend to do. One, file it with the clerk tomorrow.
Well, I can take this one and stamp it in.
Yeah.
For a copy.
Well, Joel's prefatory phrase was that we have, the planning board might have some comments to make. And do we, if it hasn't, my impression was that if it hasn't actually been filed with the clerk, and it's this is the continuation of a public hearing, we have the ability to make comments. Is that am I drawing the right inference from your comments?
You are, yeah.
Okay.
And so the last thing I'll say is, so you may have something to say about it, but we had some discussions about some of the comments I saw from Betsy had suggested the planning board making formal findings. My suggestion would be that you not do that. You've not concluded the public hearing. You've not heard all the evidence. So in my opinion, it would be premature for you to make findings. Don't have the whole picture, if you will. I know you're all, everybody's very familiar with the site. We had a very preliminary review of the application last time. But obviously, the subject matter itself is well known to all the members of the board. And if you want to comment on it for purposes of capturing it in the planning board minutes, certainly, in my opinion, that would be appropriate. I mean, clearly, there's concern, the elephant in the room is that 11,000+ square foot building is now shrunk to a building that's 1 foot below 6,000 square feet, and clearly there's concern about the site in the future, and there's concern about what's happened with the site already. But that's the landscape, literally and figuratively.
Gotcha.
So to the board, where you want to go from there.
All right, just a question. If we, in your opinion, we have the ability to make a comment. Do we have the ability to recognize comments from the floor?
You could, well, you reopened, actually, I don't know if you have, but you will be reopening the public
I
hearing.
just did.
Yeah, okay, and the applicant has said we're withdrawing the application, so that's on the record, but if members of the public want to comment,
Okay.
sure.
All right.
Be up to the board to allow that.
All right, then, in that case, if the board members don't mind, I'd like to open the floor first to comments from the public.
Thank you.
All right, let's see.
I would love for my attorney, Brian Levy, first to...
Could you just identify
Sure,
yourself?
Brian Levy. I represent Elizabeth Monroe and Peter Wheeler and Roland Lane. And really two comments. One is firstly on the procedural issue. The statute, the zoning act, which deals with this issue of repetitive petitions sort of coming back again and again on an application, talks or speaks to variances and special permits. And it specifically provides, in the case of withdrawal, that after the public notice has gone out, that withdrawal may be made, withdrawn without prejudice, only with the approval of the special permit granting authority or the permit granting authority. So in the case of a special permit or a variance, you have to approve the withdrawal after the public notice. And if you could approve it, you could certainly deny it, or you could approve it with comments. And I would argue to you that even though the statute doesn't specifically refer to site plan approval, that site plan approval is akin to a special permit, and that you certainly have the discretion, if you wish to exercise it, to grant the permission to allow the withdrawal based on certain findings that you make in the record. That you have that discretion. You may choose not to exercise it, that's a totally different thing, but I would submit that you have the discretion. The second point I would make is it would be a wise idea to exercise that discretion, because this matter has been in front of this board for a couple of years. My client has been sort of tracking this for a couple of years, has come back to the town several times to seek enforcement for the last few years. And if there's nothing done in the record in a way that a subsequent property owner will know about it, we're going to be back here again. And we have already been in a situation where town council has advised this board, unless there's concrete evidence that there's going to be construction over 6,000 square feet, the person can go ahead with the building permit. We're in that exact same box again, where town council is saying to you, you don't have to act, so don't act. That's not the right thing to do. What the right thing to do here is to take the time to make a couple of findings. We're not saying we have any objection to the withdrawal of the application. We'd like to see the withdrawal of the application. But this is an opportunity for this board to close the hole which has been opened in this bylaw. You can do this now. There are other developers that are sitting out there, they're watching what you're doing, and this is an opportunity to stop this problem. You're going to stop it as to this site, because what's going to happen is a buyer is going to come in, and we're going to be right back here again having the exact same argument. And like the Beaver Road case, it's going to be back and forth between the planning board, the zoning board, and the land court for years. You can avoid all of that with 2 or 3 simple sentences. So that's our piece.
First of all, Ryan says it's been before this board for 2 years. The last time it's been before this board was 3 weeks ago. Yes, there's been complaints when work started and the building permit was issued a few months ago. 3 weeks ago was the first time this matter has been before the board. And it sounds like he's requesting you to make some policy statements on the record about this. Without a full hearing, how would you make some? I guess you're always free to make policy statements, to work on your regulations, to modify regulations. I don't know, but I don't see a policy statements partly as a result of a withdrawal. And I guess the third thing is, I don't know what builder is watching to see what happens if Mr. Stevens withdraws his petition to build an over 6,000 square foot house and goes, and he already has the building permit and has decided to just proceed with the 6,000 square foot. So that's my comment on his comment.
Yes.
Could I just
get up.
give a
You
little
should get up.
history here? I think it's interesting.
Elizabeth?
This is Elizabeth Monroe, 111 Rolling Lane, and I am the abutter to 121 Rolling Lane. And it's true that this is the first time it's come before the planning board, but 2 years ago, it went, and Jonathan White was very much involved in this. I tried really hard to stop the devastation of this property next door to me. And the building inspector, town council, town planner, and ultimately the zoning board of appeals all addressed the issues in this case. And Joel Bard was the one who recommended that, or stated that without a definite plan to build a house greater than 6,000 square feet, there is nothing that could trigger enforcement of the zoning bylaw. So that was the decision of all of those parties, and they, each one of them told Ken Stevens that there was nothing they could do to stop him from the destruction of this property and the site work that he was proposing to do, but that he proceeded at his own risk. And the point being that if he wanted to build a house bigger than 6,000 square feet, most likely he would not be permitted to do that because the site work that he was doing would be in violation of the zoning bylaw. So a month ago, we had that concrete plan to build a house greater than 6,000 square feet. And the public hearing was noticed. We had a public hearing and a site walk, and we had a lively discussion at the public hearing. Memos were presented. I presented a memo to the board. Jonathan White did. I hired an attorney. There was a lot of effort put into that process. And I think, in fact, that is just the kind of thing that this provision in the Zoning Act is intended to address. When there is a lot of effort involved in an application, even though it's withdrawn, the board has the authority to make some decisions based on all of that analysis and review and all the effort that went into it. And in fact, these are issues that are going to come up the next time that this property, and which is almost inevitable given the background that we all know of this developer in town, that the next, either Ken himself or the next property owner will come back with a proposal for a house bigger than 6,000 square feet. And in fact, if you look at the plans, there is so much opportunity for build out of this 5,999 square foot house that he has now a building permit for. So you can almost be certain that it's going to come back. So I would implore the board, I think that you have the authority to make some decisions here, to make some findings, to add some clarity to this situation so that we don't have to go through this all over again sometime in the future.
But Elizabeth, let me ask you, what you would like for the planning board to do is to get it on the record that whatever happens on this property will be viewed by the planning board under the Beaver Road Protocol, right? Isn't that isn't that the objective here? Just to put people, to put the current property owner or any future purchasers of the land on notice that if this comes before, if whatever happens comes before the planning board through an expansion of the area, that we will view the mitigation from the perspective of the Beaver Road Protocol. Is that what you're asking for?
So the question is, what does that mean? Okay, because that's very ambiguous. I hear what you're saying. What Elizabeth is asking is that the board, in voting on the withdrawal, make a finding based on the evidence that's in front of you already, and there's plenty of evidence in front of you, that the existing terrain and landscaping, okay, that the existing terrain and landscaping under 11F site plan approval was as of July 2013 when the work began at the site. So let's not get confused with what Beaver Road means. The point is, it should be clear.
Well, this is why I love attorneys so much, because there are 4 attorneys in the room, all of whom have a different idea of how we communicate that message. The message is the same message. It's just the methodology of communicating the message.
Well, I agree
Well,
with
maybe
Joel.
3.
I agree with Joel, it's not appropriate to take a vote.
So then how do we do it?
And Brian says, the record has plenty of evidence as to what happened here. My memory 3 weeks ago was we'd spent at most a half an hour on this, and it wasn't even close to a total submission and discussion by the engineer, comment by the town's engineers. How can you say that the record is sufficient, even before you get to fact whether there's a vote, and you've already been advised by town council it's not appropriate for a vote. But beyond that, how can you say that there's enough of a record here that we're going to say what happened on this site for all time? I just think it's not there. It's not a completed hearing.
I'm shocked to hear you say that. The planning board does want to communicate a message. I know you don't agree with the message that we want to communicate, but the question is how to communicate it.
I agree with the message that Joel was sending out before, not Joel, our prior town planner, which was that you do this type of work in Ken Gatlin, you do this type of work at your own risk. And I think that's an appropriate message. I don't know what more you need to that, but beyond that, I don't think you can then insert it in a withdrawal and say, by the way, for all time, we're going to say this on this particular piece of property. No, I think it's a very appropriate.
I think you can actually warn a future buyer.
I think it's a very appropriate
Yeah.
message, and I'm not certain what I've said that's shocked you, Al.
I don't think that you necessarily agree with us that we would impose the kind of remediation that might be required under the Beaver Road decision on a future buyer of that property. I don't know that you necessarily wholeheartedly agree with that position. But if I'm wrong, please forgive me.
No, that issue could very well come up if anyone ever tries to go above 6 on this property. I agree with you.
But what
Very
happened
well.
over on Beaver Road, as I recall, was these were innocent buyers who had no idea what was going on and had no idea that the house now triggered all sorts of
You
reviews.
mean the people who bought from the developer?
Yes.
They knew exactly.
Well, maybe they did, but they
They
certainly
knew
claimed
exactly. I
innocence.
I didn't represent them, but they called me to get information.
Okay. Well, all right. Well, I
you
guess
can't
then
imagine that arising.
this is all hearsay.
Selling at $5.99.
Well, every time, that's a different issue because a lot of my practice is conveyancing. I can't tell you how many times people buy properties in town that are subject to site plan, that have been subject to site plan approval, and they have no idea what they're getting into. That's just. this is
You all
not-
explain it to them real carefully.
When I get them, I do, but I get them after the fact quite often.
Yeah.
So
So they've already bought it and-
Well, you've seen it. You've seen the people who bought properties and started cutting down trees, and they say, what do you mean I can't cut down those trees? They haven't read their decision. They've had an attorney who hasn't advised them of the decision. If you don't practice in Weston, you don't know. and you're doing a lot of conveyancing, maybe you didn't read it, but, you know, it happens quite often. You've seen that, Al. You've had to decide what to do with people who cut down trees, and they come before you and say, I didn't know I couldn't do
Well,
it.
in this case, we'll be dealing with people that have moved mountains of earth around,
Mhm.
and we'll be trying to put a site back together from conditions that existed
Yeah,
before.
but how many
that.
houses, let's go to that, how many houses in town are just below 6, were built after 1998, and if they came before you for an addition and did a lot of site movement, have the same issue? This is not the only property like that.
But this is stunningly egregious.
Well, now,
That's, I guess, how I would say it.
I totally disagree with that.
Okay.
I totally disagree. I know Elizabeth likes words like destruction and devastation. I've seen before and after over there. You know, yes, they moved it to bring it up to the same height of the house. You know, everyone can have their own definition, but yeah, if they go above 6, you have a chance to go after that and decide what's appropriate. I know.
Wait a second, Ben. So you say that if a lawyer is doing a conveyance and they don't operate in Weston all the time,
Mhm.
that they don't necessarily advise their clients of this particular little issue.
Oh, exactly.
Yes, so how can we somehow make it be in the conveyance documents that right there in the front page? And I think that that's what we'd be doing now, is we're saying this, basically, this property has had a lot of history and a lot of trouble. You're buying a house at this square footage.
It hasn't had a lot of trouble.
What?
We wrote a bylaw specifically because of this property.
You don't think this is a lot of trouble?
That's a lot of trouble.
No, it's a house that they got a building permit for 6,000 square feet. Then he decided to go for more. He saw there was opposition. He was gonna lose time,
Yeah.
money.
Well, I'm
So
mostly interested in how to make those little lawyers who don't do a good job doing due diligence for their clients really aware, so that even the client on the first page would be really aware that, wow, I'm gonna buy this house and it's on this big lot, and I can never enlarge it. That's all I want. Give them a warning, because maybe that would send a message to some of the builders that if you do this, you might have trouble selling this house.
There's all kinds of warnings that I'm writing an article now. Everyone in real estate thinks that sellers have a duty to disclose latent defects. They don't. Yeah, you know, it would be nice for buyers to know that. It would be nice for buyers to know that. But that's why you get an attorney, and hopefully most attorneys, you know, pick up on that, but not all of them do, as you've seen.
Jonathan, why do you
Joel.
not want us to do
Yeah,
this? Just a couple
yeah,
of questions.
yeah.
Why do you not want us to do
Go
this?
tell me.
What is it, what would be your purpose? The first question is do what?
Somehow come up with a couple lines that will give a history to whoever buys this house of what might happen if they decide to enlarge the house.
And where would the history go?
I don't know. That's what we're asking.
I
That's
don't
where we are.
know a solution.
These people say, these two attorneys say, we have a right to vote with findings.
Yeah.
This attorney says, no, we don't have a right to vote with findings, and you agree with them. So the question is, none of us are attorneys.
Generally, I'd take the advice of your town council, which is why I'm saying.
Can I just ask Joel a
Wait,
question?
I didn't get the answer to my question. Can I just stop for a second?
Yeah.
Why do you not want us to do this? I understand you're very passionate about us not doing
Good
it.
question.
What's behind that?
Because you're trying to put something permanent on this property, and I 100% object to putting permanent things.
But your
on-
argument earlier was that people are gonna know it anyway. So what's wrong with making it very
People
clear?
are gonna know what anyway.
The lawyers, you know, through
No, I just said the
newspapers, through
opposite. A lot of
discussions.
lawyers don't pick up on
Well,
it.
therefore,
You
we
don't
need to give
A lot of
them.
them don't know the bylaws. If you have a lawyer who doesn't know there's,
Be better
that you
informed.
have a pre-existing
So
non-conforming
then that goes to
lot,
their argument.
and you can't do an addition.
You're supporting their argument.
Listen to
No, I'm
Tony.
saying if you want to do something like that, do every risk, list every risk for the buyers. I get a lot of buyers who don't know they have a pre-existing non-conforming lot, and even though they want to do a conforming addition, they can't do it without going in front of the Board of Appeals. Their attorney didn't tell them that. How are you going to protect them from that? There's all kinds of things that buyers would like to know, but your board, I don't say that your board can selectively decide. We're going to find a way for buyers of this particular property to find out this fact. All the fact is here is that with he got a permit for a 6,000 square foot house, and yes, he did site work, and if he goes above 6,000, he may have some issues. But that's like any lot that's done a 6,000 square foot house post 1997 and then wants to do an addition. Well, most of them don't even know that they have to come in front of you unless someone tells them that, because there's nothing on the record. Yeah, you need a lawyer who knows the bylaws, but that's the situation in every town. When I do a town outside of Weston or Wayland and Lincoln, I go to the building inspector and say, what are
Did
the
he
issues?
answer your question?
Yes.
Okay.
Can I ask a little question?
Yeah.
Joel, are you telling us that we cannot,
Have a finding.
create a decision like this, a finding, or an opinion regarding the withdrawal of this application? You're saying we can't do it, or we shouldn't? Or you advise us that it's not a good idea?
Right, it's the latter, and so let me address a few of the points that have been made. I appreciate that my brothers agree with part of what I'm saying. Now, let's be clear, one is advocating for one point of view, one's advocating for another point of view. I'm not advocating for anything, I'm just advising the board to hew as close to the law as we can. I mean, respectfully, I have to disagree with Brian. The Chapter 48, Section 16 does talk exclusively about special permits and variances, and I address the fact that this is not a special permit. The case law is clear about the fact that the Zoning Act does not talk about site plan review, and they don't suggest. I'll be happy to see places where they suggest, well, go ahead and do what you might have been able to do with a special permit, or whatever. In other words, I simply don't see Section 16, which is the section that talks about a withdrawal being with prejudice if it's not assented to by the board, and therefore giving you the authority to write a decision. I simply don't agree with that. Now, I'm not saying you can't do it. What concerns me, so, I mean, if you want to do it, it would have nothing to do with what 4816 says. As far as I'm concerned, 4816 provides no guidance. But here's what concerns me, is that you've not had a complete public hearing. I mean, and that's what I was saying earlier, you're all familiar with the site. Even though I haven't been there, I feel like I'm familiar with the site. I mean, it's well known, but you can't prejudge it, and you would be prejudging it based really in part on its notoriety. And so I'm concerned that you not try to write a decision about something you haven't fully heard. The whole point of these adjudicatory processes is that you're sitting like a judge over a set of facts that you've heard. So you've not been presented with the facts of this site. You know it anecdotally, you know it from having been by the site, no doubt, you know it perhaps from having seen some of the movement that happened on the site, but you haven't heard it as part of these proceedings. So you can't be making a finding. So a finding is an act of, in this instance, truly quasi-adjudication, because now you're outside of any permit-making decision. So I just am uneasy with the idea of the board getting as formal as to make findings about this. But as I said, given the history of the site, I think if the board finds it appropriate, it'll be appropriate to, I mean, however you want to put it, I don't want to put words in your mouth, but to talk about the site, if you will. Let me just say that the issue that we're talking around here is one of enforcement. I mean, you know, it was said that this plan for the house that's 1 foot under 6,000 square feet shows ample opportunities for expansion over 6,000 square feet. I mean, obviously it's an issue you discussed and how you alluded to it an hour and a half ago now, the fact that the issue is enforcement around that. And so I think, you know, extra vigilance for this site is going to be in order. I mean, it has earned it. So I don't think it's a case of unfairly singling out a property. This property has a history that is going to call for vigilance. And I do think that future buyers, whether they come in, and I agree with what Jonathan's saying. I mean, you get all kinds of buyers. Some are fully aware, and others are, unfortunately, truly innocent of what the history is. But I don't think, and Jonathan asked the question, how are you going to make them aware? I mean, the last thing I would want to see this board do is try to put something on record, you know, to put it, to record it against the property. I mean, you're not in a position to be able to do that, for better or for worse. but if you want to say something, I'll be happy to listen to what you have in mind.
Well,
and
the
advise.
question is, what the planning board wants to communicate and somehow get out there is the message that that Elizabeth and her attorney are also communicating. We agree with them. How do we do that? How do we get that message out there? Is it just in the minutes, or is there some document that we can issue that if we can't issue findings, is there a document we can issue that memorializes that message?
Well, let's see, I mean, just thinking out loud here, so I suppose, I mean, the one thing I would be comfortable with, put it that way, would be something that you'd file with the town clerk. And
A
it would
letter,
be-
perhaps?
Well, it could be a letter, or, I mean, something in the form of a decision, but it would be a notice of acceptance of withdrawal. You wouldn't want to use the word acceptance necessarily, but acknowledgement of withdrawal, and then make some statements in that acknowledgement. You know, you're just acknowledging the fact
It
that
would be
you
a
proceed.
letter or a memorandum or
Just a notice, I mean, again,
it's a notice.
yeah,
Notice of acknowledgement of withdrawal.
right.
And in that notice of acknowledgement, what we would have is an observation.
Well, you'd start with the fact that you received an application for site plan approval
Yeah.
for a structure
So,
of 11,300.
In discussion,
Yeah.
this is the history,
Right,
it's been withdrawn.
right.
Now, where does the message come in?
Well, the history of the work done on the site, and here's where, again, I just, some of the words that you're being encouraged to put in there, I encourage you not to put in there. You don't want to make any findings about what happened there, because you haven't been to the site to really study that, but, you know, the fact that extensive reshaping of the site occurred in 2013, if that's what it was, and that the application before the board could engage in fact findings of the site, the application was withdrawn. Nonetheless, the board has concern for future owners or redevelopers of the site that any addition beyond 1 foot, or I guess, yeah, beyond 1 foot, will bring it within the board's site plan jurisdiction, and the board will then go back to look at pre-disturbance conditions pursuant to the Beaver Brook decision.
Well,
Beaver Road
Two
decision.
thoughts on that.
Oh, wait,
Okay.
yeah, no, that'd be fine.
I don't have any fire, I'm trying to work with
All right,
Can we make a suggestion? when you're-
Yeah,
Well,
just a second.
But, yeah, I mean, I'd like to have some dialogue with the board.
yes, well, I realize I'm the only one talking, and I'm sorry for that, but that's not something the board would vote on, right?
Well, yeah, so, I think that maybe Jonathan said you can't vote. I didn't say that. I said, I don't recommend that you make findings. I think you can vote on.
Oh,
on
So we can
something
vote on the
against it.
notice?
Yes,
Okay,
yes.
all right.
Yeah, so our suggestion, to try to sort of compact this into something that's workable and doable in a very short period of time, we provided you with a very short template of what we think would be the minimum number of words to convey the two concepts which we think need to be conveyed. We provided it in two formats, one where you'd be making a finding, which seems like you're inclined not to do that, and one where you don't need to make a finding, and we're just simply making a statement, taking an opportunity to clarify the meaning of section 11. It's in the email that we sent to the board, which hopefully you got on June 26th.
And we forwarded it to Joel.
And so there are two very simple conclusions, we won't call them findings. And one is, and before I say it, it's not necessary to have boiled the ocean of facts in order to come to a couple of conclusions here, okay? And one is that the facts are undisputed that there was this permit pulled to redo the ledge on the site. And that's sort of the, you know, once that finger comes out of the dike, things start happening to the property. So I think it's enough without having to understand every single, the movement of every single boulder on the property to say that the existing condition on the site dates from shortly after the issuance of the permit. So that way a buyer can come in and know, well, wait a minute, what does that mean? That means before all of this ledge was moved around, that's the existing condition that you're saying that you're going to apply in the future to any future site plan application. So doesn't seem to require a full set of facts. There's not a lot there to rely on. And the other principle that we propose that you announce is that the board finds that that work at the site that was performed does not comply with the standards and criteria of 11F, which mandates that development be integrated into the existing terrain, surrounding landscape, that building sites shall, to the extent feasible, minimize steep slopes, preserve natural features, and minimize tree, vegetation, and soil removal, blasting, and grade changes. 2 simple points. That's it.
Could I add one thing to that too? The facts as to that, the ladder, and the grade changes and the blasting and the tree removal, the facts are there. We don't need, 3 more public hearings. There was a site walk, and there is the proposed site plan and the site plan after all the site work was done that shows all of that work. So I disagree that there hasn't been enough discussion at public hearing to make this.
Well, I think the discussion would have revolved around, could we impose conditions that could mitigate the work that was done?
Can you restore rock ledge?
Well, my point is, since we haven't reviewed it, it would be impossible to say. It may be impossible, but without at least some review.
So one thing we started doing, and then we just decided we weren't going forward, was comparing sites where far more ledge was disturbed, where site plan approval was granted. So I don't know how this board could, without a hearing, make a decision that, like that. I don't see how you could. And I'll give you, it's a different example, but have a property, I'll just say it's on Meadowbrook, kept it just below 6. I know the person clear cut just about every tree on that lot. Should you put a decision on that particular property so that every future buyer will know if they go above 6,000, they may have to put a darn.
But did they come before us recently to build an 11,000 square
No.
foot house? Okay,
No.
There
so
you go.
why would,
So
why, so what are we
why
talking
would that
about?
make a difference?
It makes a huge difference. They
So
haven't
this
come before
turns
us.
on the fact that he came before you and then decided not to go forward.
Yeah.
I totally disagree. Why would
Well,
it turn?
that's your right.
Why would it turn on that?
So,
Why would
anyway,
it turn on
it's
that?
getting late.
Because it's actually better if there's more notice if someone takes the time to check the record to see that someone started and withdrew, than that there's been absolute silence. That's more a trap for the unwary than this is. So really, if you're gonna do this, I suggest it compels you to look at every house built after 1997, see if there was major site disruption on a house that was kept below 6,000, and put the same type of warning wherever you want to put this one. I suggest that the fact that he came before you, saw opposition for a larger house, and then withdrew, why should it turn on that?
No, I respectfully disagree. Let's stay on this particular property. Joel, if you don't mind, I think where we are here, and let me just try to summarize it for everybody so we can move on. I think where we are is we have town council's advice that we can't really make findings, but we can do a notification. Which it sounds like it's a short one or 2 paragraph notification. Joel, is that something you could draft up reasonably quickly and send it around and then we could I think we should vote on it, and we vote on it at our next meeting on the 15th. All right.
Yes.
Betsy, have you sent
And
this
then
to
we won't
Joel?
get into the
Yeah.
tall weeds of whether we should do it for every house in
If
Weston.
you're going to do
Yeah.
that, I'd like to
Yeah.
continue the public hearing to have a chance to see that document.
Sure, we'll continue it to the 15th. We'll continue it
The
to
other
the 15th.
the other thing I
Will that be
was,
circulated to all the abutters?
Well, it'll be discussed at the hearing.
I mean,
So-
just in terms of seeing it,
You mean the draft?
yes. We're,
Could I have
just,
your name for the
I'm Joe
record?
Ryan, we're one of the abutters, so.
I think we could.
Well, I could get it from,
once we-
I could get it from the town.
Yeah, I think it'll be a
That-
matter of
that's
public
fine.
record after we've
Fair enough.
had a chance to look at the draft.
the only other suggestion, it's just a suggestion, is I've lectured to the 3 largest real estate offices in town, trying to make them aware of these pitfalls, but, yeah, a letter from the planning board asking each real estate office, you know what you usually see.
Why don't you
for
talk to
property.
Betsy about that? I don't think that's something we need to get into right now.
Well, I think it's a better way to do it than pick on this one property
Yeah.
and not select any other properties, because I will totally object to
Good.
that.
Well,
Oh, is that
that's-
good?
That'll be interesting.
Okay, I'm glad.
That's sometimes good. All right, good. Yes.
Diana Chaplin, 26 Love Lane. I would just ask the board to not only leave the responsibility of this sort of disclosure to the real estate companies in this town, because so many properties are sold to agents that are outside of this town, and it unfairly burdens, I mean, we do the best that we can, but to expect that a buyer comes in knowledgeable when they're working with an out-of-town agent it's naive on the part of the board to assume that education happens. And amongst the agents in the town, we do the best we can, but that's a huge responsibility, and it's not fairly distributed amongst all of the agents who are selling with these buyers.
Well, I think,
Just give them a handout.
Handout, what, to the agent who comes
No,
from
you do the
Boston
best
and
you
the
can.
one from
No,
Framingham?
you do the
I
best you
mean,
can.
Yeah, but it's
Just
not,
like Weston is a farm-friendly town, every buyer is supposed to get a notice there. Some people do it, some don't, but at least
can you
make
guys
them.
actually not talk to each other? I mean, it would be that, look, again, we're here considering a particular decision. If there are suggestions concerning the ramifications of that decision, my suggestion would be that you might talk to the town planner about those suggestions. But this is not gonna be part of the decision that we make on this particular application. And if you think there are global implications, there are global implications to every decision. So, the consequences we'll have to, work through. But this is, at least I think, this is the consensus on the board with respect to this particular set of circumstances.
I've heard 2 board members comment on that, Al.
Yeah, I'm asking the other boards or members if they agree with me.
Agree with what?
With the idea that Joel's gonna do a draft of the
Well, I'm
notification.
open to, yeah. I'm open
And
to
the
that.
draft is going, so you're gonna look at the draft, decide if you accept it, and where would that draft go?
Go.
The town clerk?
Yeah, town clerk.
I agree, absolutely.
Steve,
I'm sorry.
do you agree with the idea that we're gonna go ahead with the notification?
Yes.
Okay,
Thank you.
Thank you very much.
all right.
Thank you, everybody.
This is like, every single Tuesday. This is just. It's placed it in there.
I can, he sent it to me electronically.
Hey, Joel, when was that Eagle Road decision? Ish, I'm just how long
December.
Prepare a study, booked,
Yeah.
So, but between now and then.
Remember, Beaver Road only
Because I
hit the
don't know all
fan
the history that you guys know about that.
once
property.
they
You know
went
what I'm
over
saying?
6.
That's the only
They
reason. I
gave the
asked.
system, they started off.
December
with
2011.
Okay. And how many situations like that have we seen since?
Well, depends who you talk to, I mean, there've been a bunch, yeah.
Okay, where you have a naive buyer who's bought into this situation?
Well, you have to,
Generally not so naive.
Okay.
no, I think there's a fair amount of them that are. Like,
There are?
Yeah,
You know?
yeah, the developer was just under X amount of square feet, and so, for example, we have somebody on Montvale who came in and they bought a house, and the second garage was only like half size.
Oh, yeah, that was a good one.
And they didn't know.
They had no idea why they couldn't get a car in the second garage.
So is this happening once a year, once
No.
a quarter?
These people would not be allowed to, they would not be able to afford living in this town if these houses weren't built under the RGFA. You guys are just pushing this lower tier of families out of town. Stop it. You're making houses so expensive. Careful, please.
The ones that get fooled more are the ones that were built
I'm trying to figure out how
2004,
to do that.
2003. The dust is settled, and they're right under 6, and then the person wants to build an addition, and they have no knowledge, but, you know, I guess the public.
Or under 4, or under
Let me just get back to
3,500.
Joel. So the concern is you have a naive buyer coming in and knowing what they're gonna have to go through, and these folks don't want to have to go through it again. How often does that happen when you have a naive buyer come in?
I don't know.
Okay.
Because I don't see,
Okay.
I don't see the trend.
Many
I don't
times.
see the routines, yeah.
I'd only say half the time. Really, it would only be half the time. I don't think it's more than that.
Is that the
And I
first
sell,
one?
I don't even think it's that much. I mean, we sell a lot of houses in town, and there's definitely a good percentage on the new construction that's coming through, but it is not. I mean, I feel sorry when they do come through. I'm not saying there's not a lot, but there's not, I mean, probably, what do you think? I don't
Well,
think it's.
I think whether it's, since it's 1998, since this first started, I think we have people who aren't doing it, who bought the house new, but who resell it or sell it again, they come in. I mean, you had that up on King's Grant a few years back, where the people came in and wanted a mudroom and a bigger master bedroom closet, and it triggered the RGFA review. So it's eternity. You know, these houses are never, ever gonna not trigger review. So the more and more of them there are, and the more time that has passed, the more you're gonna see this.
I mean, even screened-in porches have to come back. So, you know, whether they're screened or they just want a glass porch because we have bugs and it's cold, we only have 2 months of nice weather. I mean, they're coming through for just, you know,
This is, look, we can have this
Discussion
discussion
for
but
another
not
time.
No, I
now.
was just doing it during breakfast.
Yeah, well, yeah, let's
Okay.
move on.
See you in 2 weeks.
Yeah, okay, thank you,
Good
Jack.
one.
Armed and dangerous, right, with all kinds of decisions.
Thank you.
The armed and dangerous was metaphorical.
Yeah, yeah.
Yeah.
You heard that, Al?
Yeah.